Yeah, we'll get you in mind when you guys decide next week. Yeah, we're gonna do it. Okay, you'll hear from me pretty soon. Excellent. I love it. I'll get you in there. I reached out. I have talked to those guys for a long time. Okay, and it was like, okay, well, don't be strange before okay, I don't know, I love that stuff. I got a new computer. Yeah, well, I do. You can get it.
You're not.
That's basically going to be.
That's hard.
You're limited on like, you know, you're not gonna be able to. I'm sure you.
Yeah, I know it's going to be like.
Yeah, I got your phone stuff, I just, you have my, what's your?
I have your email.
I had damage, got like, wow.
No, that's not
Really?
Yeah.
Oh, really?
I can't think of that. You still have your? Yeah, but. Yeah, and I'm in a lot. All right. Wait, I said stuff I have, like,
Did you record it?
I'm looking up this.
It was a.
Do you ever see Junior in there? Or is that?
Okay, you called it. Michigan Free.
All right, we'll get together. We got a whole week. Excellent. Okay, look forward to seeing you. Thanks, Mark. Hey, Mark.
She was just like, she held passes. And I just kind of really get to think of where it's going to go on, and I was just like, crying.
So I had one case that was basically like, it was like an accounting firm, and all their accountants went to work for a different accounting firm in the same city with the same client, and they were like, as long as those clients work with different accountants than the ones that work with you, it's totally fine.
Wow.
Like they could totally work for a different firm in the same city, it's just they can't work with the same client. And so I ended up just hanging my hat on that for a while.
Coaching, that's actually coaching.
Yeah, that's basically what we're like, it's totally fine. You know,
Because
personally,
because
feel
the customers will have to change that they want. I had someone who was management recruiters. Same thing, like it was a headhunter. They were like the client that he was headhunting for, he could work with. He could say at their discretion, but he wasn't allowed to use like because that was
well, that's
trade.
great, yeah, but then it has.
And he was like he went off on I feel like it was interesting. have the last semester we did citation jeopardy.
That's what we did.
So we have a number of rounds this semester, and last semester the grand prize was like a little cake from testing, and we were like, okay, we want. No way. Yeah, I was like. That's not bad, actually. I would take that. I think it's cool.
Yeah, so it's just weird how much we're out here.
I mean, you probably actually there was one time when they told us to read. It was like near the beginning of the year. And I remember trying to, and we was so bored, and we didn't.
Everyone's like, oh, you use it. Like, sure, that's exactly right.
You know, I would be able to make a lot from cardio, everything I've turned into actual research. Terrible, who are those for?
Yeah, I suspect I'm probably a little better than most people, but I still don't know. I don't know.
I don't like, I keep trying. I'm too used to try that. Too many years.
Well, yeah, I haven't studied a lot of that. No, that's what you do. When I call it up.
I,
But I don't know everything about that kind of
probably you can't even get into your state bar.
I'm much more about
Power to do. I mean, like, you're in future, so you should move on.
Well, yeah, he's definitely So it's someone like me who's there, and I'm like,
I love it.
yeah, I still feel bad about that. Yeah, I think that is one of the very,
You watch the test one?
trial for justice will have to, I don't think possibly.
Put it this way.
And well, unfortunately, the team that's actually shot it, they only have a few guys, like, they can't, maybe you're trying out for it, they're not. So, oh wow, that was really bad. Yeah.
Well,
I'm gonna be like, there's definitely
Wait,
people.
so where's prison?
Oh, yeah, there are people in my class that I, there's stuff in our class where I like had called me teachers for a little while. Yeah, that was really nice.
Oh, we have a little bit.
We might show it like the students, because they can come up for in class introduction better than everybody else, and they end up lecturing. And it's like, you're a student, like, I don't.
We just have a couple who really love my son. And it's not that actors end up with like problematic, it's just that it's going to people every single day.
I know this college is like changing.
Well, what if I change it? How would that change? Don't change their hypothetical, change the case.
We literally spent an entire day with them giving hypotheticals on process, like service.
I just,
That didn't matter.
did you, I totally just laughed. Literally all said anymore. Do that, and she was like, that's fun.
It was like, well, what's your plan? She, and they, that's pretty bad.
Testing my network.
That's exactly what's happening. Because we had just finished summarizing the whole thing, like as we're finished summarizing. I just want to make sure I understand. What he's saying is Congress isn't doing the analysis. His face, he was just. He doesn't have a poker face. Is that what it is? Absolutely. Like, so he just has a radio, yes, right there. He's just like. I like he's really intimidating because he's and that's weird. Yeah, then I'm like, you didn't have perfect, and I was right. I don't agree with you. Yeah. I mean. Right. For the most part, our class is pretty sure. I don't like the experience, but summarize everything that he's saying. No, like, no, I get it.
Test 1 2. Test 1 2. Testing 1 2. Test 1 2. Testing 1 2. Test 1 2. Testing wireless microphone C. Test 1 2. Test 1 2. Testing 1 2. Testing wireless mic D. Test 1 2.
Got your care package. And did, there's a student who takes photographs.
right. Hello, everybody. Let's go ahead and get started. For those of you who do not know me, I'm Michael Scharf. I'm the co-dean of the law school, and it is my great privilege and pleasure to welcome you to today's speech. This speech is sponsored by our Institute for Global Security Law and Policy. And the director of the Institute, Avi Cover, I just Skyped with this morning. He's in Kenya on a Fulbright doing some really interesting human rights work over there. And he asked me to say a big greeting and a hello from him to all of you, and to thank you for coming today. We have a wonderful speaker today, and I want to start by thanking Jim Johnson for organizing this. Jim Johnson is an adjunct professor who's also the director of our Henry King War Crimes Research Office. And for those of you who don't know Henry King, he was a Nuremberg prosecutor who taught at our school for 30 years. He worked for that gentleman, Robert Jackson, who was the chief prosecutor at Nuremberg. And he was the one who recruited me to this law school, and he was good friends with all of us. Jim not only teaches international criminal law, but a war crimes research lab where our students do real world work for international tribunals. And he was just telling me about some of the legal issues we've been assigned by the International Criminal Court and some of the other organizations and tribunals, including work with the worst crisis that is now affecting the world, which is the crisis in Yemen. And one of the things that Professor Johnson has done this year has been to launch our Yemen Accountability Project. And this project is being funded by the John F. and Mary A. Geese Foundation, which is a foundation that's very generous in the area of human rights. And we have one of its representatives, Tim Geese, in the audience. Thank you for being with us, and thank your foundation for its support. The Yemen Accountability Project is a project where our students are mapping the war crimes and crimes against humanity in Yemen. And there's nobody else doing that work around the world right now. They will create a crime base, they will create draft indictments, and that will be the foundation for whatever accountability comes in the next level when the international community gets ready to start focusing on that. And you all know there's a lot going on in Yemen. We have a student, Laura Graham, right there, who is the student director of this project, and she has a staff of about 60 students, 75 students who have volunteered. How many of you in the room are part of that project? Well, thank you all for doing that. I like to say this is a law school where our students like to come because they want to make an impact in the world, but they don't have to wait to graduate to do that. They can start right when they're in law school through the War Crimes Lab, through the Yemen Accountability Project, and through so many other things. Now, our speaker today is somebody who a lot of you have already met in the past because this is his 4th time with us, and we are extremely fortunate as an institution to be able to attract someone of this caliber to speak to us over the years. And it's a long time in between some of these. So his career started out as a U.S. attorney in Iowa, and then he became a prosecutor at the Rwanda Tribunal, prosecuting the genocide in Rwanda. And then he became a part of the Special Court for Sierra Leone, and ultimately he was the chief prosecutor of the Special Court for Sierra Leone. Later, he served during the Obama administration as the ambassador at large for what used to be called war crimes issues and now is what, international criminal justice, global criminal justice. And currently, he has a number of really exciting projects. So this is a man who is not easily fatigued, and he has more miles around the world than anybody I know, and every time I talk with him, he's doing something else exciting somewhere in the world, including work in the Yemen Project. He's on our board of advisors for the Yemen Project, and Jim Johnson brought him in here to work with our students, to meet with our students, and to give this lecture today. I'm not going to steal his thunder about what the lecture is about, but it is absolutely relevant, cogent, and exciting. And so without further ado, please join me in welcoming Stephen Raff.
Well, thank you, Michael, for that enthusiastic introduction, and thank you for your leadership in this field. We're all looking forward to that book on the Yugoslavian Rwanda Tribunal, which you'll be giving away, I understand, in Washington next month, and I'll be standing in line for one, and really appreciate the work that I've benefited from. Both in my time as an international prosecutor, particularly when I was working with Jim Johnson, who was our chief of prosecutions when I was chief prosecutor at Sierra Leone, where you were always sending us fantastic interns, and we were benefiting from the work of the research projects and labs, and that's continuing now in this new phase where I think that work is even more important, and you'll. And as I sort of develop my theme today, you'll, I think, perhaps see why. Because to be frank, the situation has changed when it comes to international criminal justice. The conditions are not as good as they were in the past. You said I spoke here 4 times. I think the first was on the Katyn massacre, but the first time I spoke on international criminal justice, I think was 7 years ago this March, March of 2012, at the Cox Humanitarian Award lecture at the City Club. And the situation then with international criminal justice was quite different than what it is today. Just the previous year, the Security Council had unanimously, by 15-0, referred the situation in Libya to the International Criminal Court. United States, China, Russia, all supporting that referral. The previous May, 9 months before I spoke, Ratko Mladic, who'd been on the run for 16 years, alleged to be the general responsible for horrible crimes in Bosnia, including the genocide at Srebrenica, was finally arrested and brought to justice in The Hague. Just 2 months after that, the last fugitive, Goran Hadjic, was arrested in northern Serbia and transferred to The Hague. Indeed, that Yugoslavia tribunal had charged 161 people. It brought all 161 to justice. It cleared the basis, something that was almost unheard of in any kind of court system. Today, however, human rights generally and international criminal law, and criminal justice, which deals with accountability for really the worst violations of international human rights, are facing headwinds that are pushing against progress. You have, active opposition increasing from countries like China, particularly under the current leader, Xi Jinping. In the past, even there, a recognition that human rights were universal values. Indeed, it's a universal declaration that every country is subscribed to. But now, these are Western, foreign ideas that should be resisted. And certainly, the enforcement of those rights, when they're violated in horrendous ways within the borders of a single state, and enforcement without the consent of that state, it is something that countries like China now almost universally oppose. And you can see why. Obviously, what happened in Tiananmen Square was a systematic suppression that could be called a crime against humanity. The internment, imprisonment, re-education of 1 million Uyghurs at the present time could be called not just widespread, but systematic crime against humanity. So you've got that kind of resistance and that kind of conduct going on without intense international criticism. And there's resistance to cooperation with international courts, even on the part of countries that should cooperate and are required to cooperate, such as the trial of the ICC fugitive, the president of Sudan, Omar Bashir, who's actually been under an international arrest warrant since March of 2009, 10 years next month. And he's been able to visit DRC, Malawi, Chad, Jordan, all state parties to the ICC. And obstruction when it comes to bringing cases before the ICC that involve massive crimes for which there has been no accountability, like those in Syria that I've spent so much time on. I'm glad to talk about in the question period. I was just in Ottawa yesterday talking about these crimes, the 500,000 dead, 13 million displaced, the violations of norms that we thought had been well established, like the protection of medical personnel, or the norm against the use of chemical weapons, the use of forced disappearance, crimes that we thought we turned the corner on are being committed almost and often in plain sight. And the effort to bring that to the ICC on a resolution that came before the Security Council in May of 2014 got 13 votes. That's a lot of votes out of 15, but 2 no's, Russia and China, which were vetoes, and killed it. And then when we come to other internationalized approaches, the peace agreement for South Sudan, for instance, provides in Chapter 5 that there will be an African Union hybrid court to deal with accountability by political leaders and military leaders on all sides that have displaced 4 million people and killed and raped tens of thousands. That was agreed 3.5 years ago. It was renewed in the revitalized agreement, and there's yet to be any progress in its establishment. And even where countries say that they're going to have transitional justice, like Sri Lanka, after it had an election in which those that opposed justice were turned out, and there was great hope. A government came in, co-sponsored a Human Rights Council resolution saying that there would be 4 pillars of transitional justice established in Sri Lanka for the alleged crimes that occurred during the conflict with the LTTE by both sides. Of those 4 pillars, I think we've got about half of 1 pillar built, and the government's now advocating eliminating that transitional justice plan. So this is the global situation that we're facing today. The pressures against, fundamentally, the absence of will to see justice delivered for the victims and survivors of these atrocity crimes. And at the same time that we've got those conditions, the sort of headwinds that are blowing and pushing against this, there are problems with the institutions themselves. The fleet is not what it was, to be frank. To some extent, there's a loss of crew. That's understandable. We had, when the Yugoslavia and Rwanda tribunal were stood up, one time when I was chief of prosecutions, had 12 senior trial attorneys, 2 of them Americans, P5s, that were working under me. There are now nobody in those roles in the residual court. 50 or 60 people who had served as judges on a full-time basis, deciding cases, are no longer working. And certainly for those of you that are passionate about this issue and looking for careers or opportunities to work in it, the closure of those tribunals, which were frankly the Yugoslavia, Rwanda tribunal, the hybrid court for Sierra Leone, were to be temporary institutions. The passage of those from the scene is expected, and some people thought they took too long, frankly, to finish their jobs. But that means there's less global engagement on this at the moment. And then, of course, we have the ICC now. And I can glad to talk at length about the International Criminal Court, but of course we recognize that the United States is not a part of that court, as of course China and Russia are not a part of it. It has 123 countries, but not the 3 that I mentioned, and not Israel or most Arab countries except for Tunisia and Jordan, practically no countries in South Asia except Bangladesh. And so it's limited in its ability to deal with things. And in terms of Americans working in that court, and I know there are people here and elsewhere that have worked as interns. There are a few Americans that are hired there. It is possible, but their system appropriately says if you come from a state party, you have a preference because we're paying the bills and you're not. And so we don't have the number of Americans working there that we used to. And I know that's a concern for myself in particular, because frankly, and I'm not an American exceptionalist. I think every country does things in some way exceptional. But I do think, and I will argue this with my friends in Europe and elsewhere, but from the United States, we have people that go out and work in these institutions who really have a practical, can-do attitude. People like Jim Johnson, David Crane, and others. And we've seen it before in World War II, and we saw it at Nuremberg. And frankly, as the United States has recognized its own problems with its law and its absence of diversity in the past, and as those problems have changed America, the Americans that are involved are also much better able, I think, than even in the past, to work comfortably in all sorts of places with all sorts of people, even more so than people that come from Australia or other countries. I really do think that I see that in the way Americans conduct themselves in these institutions and get the maximum out of everybody. We also have, I think, the experience, and we see it now as people are following federal prosecutions, that, you know, our system, and it varies from place to place, but what we see in federal prosecution, for instance, where attorneys actually lead investigations and work with the police and work with the investigators and build the file, and approve the search warrants and the T3s and the agreements with cooperators, et cetera. And then the same people go into court and advocate and win those trials. That's a skill, a combination of skill sets that you don't frankly get in most of the rest of the world. My friends from civil law countries come often from businesses, from careers working as magistrates, and they investigate on the ground, run police, et cetera, do that, but they go to court, they have no idea what to do. In Britain, for instance, you have people that are great barristers, better often than Americans when it comes to really the great skills and journeyman skills in the courtroom, but they don't deal with witnesses directly. They don't investigate cases. That's for Scotland Yard, or it's for the solicitors or the Crown Prosecution Service to do that. And so as a result, we had people like Mark Harmon, or Alan Teager, or Pete McCloskey, or Brenda Hollis, people who were fantastic national prosecutors and just became the stars at the international level. We've got this young Jack Smith, who's recently taken over as prosecutor in this Kosovo court, which I can talk about, which is one example of something new that's happening. But it really is, it's something that we're missing now in terms of crewing this fleet. And of course, the ICC, the United States, isn't a party. In the beginning, in the second term of President Bush, the United States, President George W. Bush, began to take the position that we would work with the ICC as long as it was doing things that we thought needed to be done. During the Obama administration, we took the position that we'd look at the American Service Members Protection Act, that famous law that Congress passed in 2002, that our European allies called the Invade the Hague Act, et cetera, but the act that says that we can't cooperate with the ICC in certain ways, but it also says that we can, basically on a case-by-case basis, provide in-kind assistance to the court as long as they're pursuing cases involving non-citizens that are alleged to be responsible for genocide, war crimes, and crimes against humanity. So we took advantage of that to help the ICC build its own tools, and particularly helped on the fugitive issue. Today, there are 2 people on trial in The Hague, only 2 left, actually, at the ICC that are on trial. There are 2 cases now, new ones, that are awaiting pretrial proceedings. Those 2 individuals surrendered to the United States of America, and Uganda to our embassy in Kigali, Ungwen to our forces that were supporting the counter-LRA operation in northern Central African Republic. And we worked on the strategy that delivered those people to The Hague, to prosecutions. Of course, the ICC is looking at situations involving our allies, and has been for a long time looking at the question of Afghanistan, which is a state party, and allegations that enhanced interrogation there by American agents may have crossed the line into torture. The position we took was to engage and show that we were dealing with those cases ourselves, and that in certain ways, things that they were looking at didn't qualify under their statute. Now, as that case, and it still hasn't been authorized for opening by the judges, is going forward, and now that we have a new administration and John Bolton as National Security Advisor, the approach is to become intensely hostile to the ICC. Of course, Bolton in 2002 famously did the so-called unsigning of the Rome Statute. He wanted to strangle the ICC in its cradle. Now his position in 2018, let's strangle the teenager in his bunk bed. We're going to kill the court even where it's doing the right thing. That's the threats that were in that speech to arrest anybody who came from the ICC. The ICC president will speak at the American Society for International Law in Washington in March, put out a warrant and arrest him. I'm a former United States attorney, as you heard. There's no basis for that. That's certainly bluster. But our cooperation is suspended. The U.S. is also out of the Human Rights Council. The Human Rights Council is not perfect, but during the last 6 years, we pushed for the establishment of commissions of inquiry dealing with atrocity situations where the Security Council was blocked in places like North Korea and in Syria. and in Sri Lanka and in Myanmar, that it wouldn't have happened if it had been in the Security Council. There would have been a veto. And now as they continue at the current time to look at these situations, the United States isn't there to lead the pack. So there's no question that I think that we need to get back into this fight. There is also a part of the institutions, and one has to recognize that there are self-inflicted problems, ways in which, to keep the nautical metaphor going, these institutions are sort of scuttling themselves. You see it in the judicial narrowing of some of the well-established legal doctrines. For instance, at the Sierra Leone court, we benefited enormously from the legal doctrine that which came to us from Nuremberg, from the subsequent cases at Nuremberg, that if you aided and abetted those that were committing monstrous war crimes, and you knew what they were doing, and your aid was substantial, you were guilty of those war crimes, even though you didn't prove that you actually intended that you committed those war crimes. That was well-established law at the ICTY. We had a case, Perisic, where it was said, no, Perisic, who was the chief of staff of the Serbian army, who provided tens of thousands of arms to the Bosnian Serb forces that were engaged in ethnic cleansing, in the siege of the civilian population of Sarajevo and in Srebrenica, etc., you'd have to prove that he specifically directed that aid to atrocities, sort of like right on that case of guns, use these to kill women and children. It became much more difficult. So Perisic, responsible for so much, was in the end acquitted by the appeals chamber. We had the case in the ICC in Bemba, acquitted by the appeals chamber by narrowing the doctrine of command responsibility. It was his guys that were committing these rapes and murders. He knew about it, but the court thought he was too far away to have done anything about it. Most recently, the decision in the Blaigude and Gbagbo case out of Cote d'Ivoire. It's on appeal now, but it's a decision on a no-case motion in which they said, well, there were massive killing of civilians to aid this effort to essentially steal the election, but we don't have sufficient proof that there was a plan or policy to do it, almost seeming to require that for every time you have crimes against humanity, you need to have like the Nazis had, a Wannsee conference where they agreed on the final solution for the Holocaust. That's not the way people commit these crimes. And when they're committed as these are, and when people contribute to them, the need for an explicit agreement, when clearly there's an implicit one that's being followed, seems, I think, to make it almost impossible to hold the people responsible who are really responsible for these crimes, the ones who stand to benefit from them. And frankly, at the ICC, there has not been rigorous enough investigation. We saw that in the Kenya case. Sort of, let's have enough to indict, but what about enough to convict? And frankly, as a former prosecutor, I always had the attitude, you need about twice as much evidence as you think is reasonable to convict. Frankly, at the international level, I think you need about 3 times as much, because you're going to lose evidence. Witnesses are going to be intimidated. People aren't going to remember their stories, remember the truth. They're going to get confused and start describing a world in which, because they don't see the world in a map and they don't keep time by a wristwatch, they'll be using inconsistencies in their times and places, et cetera, even though they're trying as hard as they can to tell you the truth. So you really do need to do a better job. Now, all of that would sound to be, intensely pessimistic. And let me grab some water here while I turn to the brighter side of all of this. The suggestion that even as we see these headwinds, there are positive things, I think, that give me real hope for the future. I often talk about international justice, and others do, and again, I guess it's part of the nautical metaphor, in seeing that we do have waves of activity in this area. At Nuremberg and Tokyo, in the period after World War II, we had this first great wave, obviously benefited by the very clear political decisions made to hold the Nazis to account, by the power and might of of the occupied armies that made the arrest, collected the evidence, staffed the trials, etc. And of course, when that coalition of countries involved in that fell apart at the beginning of the Cold War, beginning in certainly 1948, 49, it was no longer possible to have justice in that way. And then we had the second wave that began after the end of the Cold War, when there had certainly been atrocities during the Cold War, but we had situations like the Rwanda genocide, like the breakup of the former Yugoslavia, where massive crimes were committed. And the UN Security Council, representative of all the great powers and the additional states that serve on a rotating basis, could unite around this idea that after these crimes are committed, that holding the perpetrators to account and doing it under the UN Charter as part of the Chapter 7 of the UN Charter, that provision that provides that when the UN Security Council acts in the interest of peace and security, it can essentially establish mandatory rules for all the world. But under Chapter 7, you could say one of the ways to reestablish peace and security in these places is to hold the perpetrators to account. And we had the establishment of those institutions. And even as we went forward with things like the Sierra Leone was initially authorized by the Security Council. It was, of course, a consent-based court with the government of Sierra Leone agreeing. Similarly, there was UN agreement, though through the General Assembly when it came to the Cambodia court, though getting state consent to a sort of fully independent process was a much more difficult challenge. And of course, the ICC itself involves a situation where the states that it applies to are those that have ratified it, and the only way to get other cases to it is through referral in the Security Council. And when the Security Council is blocked, you're nowhere. So that was the second wave. And indeed, with the things that I've just described, that wave is certainly flattened. But now I really do see the development, and it's been a time in coming, of a third wave. And a third wave that doesn't rely on necessarily the support of all the great powers or of the United Nations. I think for an example of a case where success was achieved as the Habre case. And I don't know how familiar you are with that specific case. It didn't get a lot of attention in the United States, but there was a dictator of an African state, Chad, in the Sahara and Sahelian region of East Africa. He was in power from 1982 to 1990. Eventually became paranoid, eventually went after almost various ethnic groups that he thought were opposing him, eventually after people that had been in his own insider group. When he was finally overthrown in 1990, there was a truth commission that found that he tortured at least 40,000 people and killed thousands of them. And that truth commission found documents that were in his own hand, back from the torture chambers, saying, don't let this fellow get out of this place alive. So it was extremely strong evidence. The victims, the survivors of that, were passionate about justice. It was very hard to succeed. The United States had supported, France had supported Habre because he had been fighting one of Gaddafi's proxies in the northern part of the country. But the victims continued to press. Eventually, they had the NGO assistance of Human Rights Watch that went in and got the documents and said, my heavens, these are the best documents we've ever seen in terms of direct implication. They took him to Senegal. Habre had fled the country, gone to Senegal, 2,000 miles west on the West African coast. Emptied the whole treasury. Every CFA in the treasury he took with him, brought out a check. Lived the life there, tried to buy himself protection. And so when they came to Senegal and say prosecute him, initially there was support for that, but then politically it was blocked. They then went to Belgium, which then had full universal jurisdiction. They had some Chadian victims there. They were able to start a case. And the Belgian prosecutors have been doing Rwandan cases and other things. Boy, this is great evidence. We haven't seen anything this good. Eventually, Belgium wanted him extradited. They took it to Senegal took it to the African Union. African Union said, Senegal, you do this. We don't want these cases in Europe. So they brought pressure. African Union joined the efforts. Belgium actually then sued Senegal in the International Court of Justice, saying this is torture. You're either supposed to extradite or prosecute under the Torture Convention. Eventually, the ICJ, International Court of Justice, said, yes, you need to do that. Either send them to Belgium or do it yourself. And meanwhile, the United States, the EU, and other countries got aboard, and we had the victims visiting the State Department, et cetera. And the United States certainly pushed the Senegal government very hard, particularly to have a free election, as it had in the past, not to stack the deck, and the regime was defeated, and somebody came to power and said, let's do the trial. And we were able finally to negotiate an agreement to have a special tribunal, almost all Senegal judges, in Dakar. And because it was a civil law system, the victims themselves had lawyers, prosecutors. And some of the best lawyers in court were the victims' lawyers, who brought forth their own victims to testify. There was a public prosecutor, a friend of ours, who did a great job as well. And in the end, in this case, finally finished, I was there for the final appeal when it was resolved in March of 2017. He was convicted of crimes against humanity, war crimes, murder, torture, sexual violence, sentenced to life in prison. And that was the kind of case that didn't require, I mean, Russia and China never had to give their permission to that. The United States supported it. It was important that we do, but it could have gone forward without us. But of course, given our influences, which is even greater than France, to be frank, in Senegal, it was an important part of it. In a way, we don't have the sort of the big boats that we had in the past. There are smaller boats, but there is an amazing number of places in which we see international justice moving forward, and these norms being applied. For one thing, the victims are activated. Jim was talking about my frequent flyer miles. I just boast about how much time I travel, and while I was in the State Department, I traveled 220 days a year. In the end, it was 1.5 million miles to 87 countries. Now, that's not to the south of France. That's to the Congo 15 times, back to Sierra Leone, to every place where there had been these kind of crimes. And now for the Holocaust Museum, I still did it. In 2017, I traveled 280 days. Last year, it was down to only 241. Next week in Ethiopia and Rwanda. And so, but the point is, everywhere I go, people say, why not justice for us? Look at these cases. Look at these decisions. Look at Taylor. Look at Milosevic. Look at other places where there's been justice. And they're pressing for this in historic crimes, but also in the current one. And they're benefiting from the law that's been established in these courts and the application of that law, sometimes through amendments, sometimes through automatic rules in which international law becomes part of national law. They also have partners, like the students at Case, et cetera, and elsewhere, helping build their skills and their ability to document it. Because at the end of the day, the thing that saved Habre more than anything else, good evidence. You can have somebody that everybody thought was the most evil person in the world, but if you can't prove it, you're nowhere. And so helping them build the good contemporaneous evidence is a key part of it. And the partners that are working with the victims are part of it. Then we have NGOs that are very specialized. I'm proud to be volunteer chair of one called CIJA, the Commission for International Justice and Accountability. It received initial funding from the United States, but now none from the US, but from a great many other countries, has a budget of around $6 million a year. I was just with its leadership in Canada yesterday. It's been heavily focused on Syria and Iraq. In Syria, it's brought out 800,000 pages of documents in various areas. It has 150 people working for it, at least 80 of them Syrians or Iraqis. It's written pretrial briefs on 16 major criminal enterprises, et cetera, within the Syrian regime and in ISIS or Daesh. It has an index now, which was last year there were 79 requests from international law enforcement, 600 different individuals. It's got an index in Arabic of 2 million names of people in the Syrian conflict, victims, perpetrators, bystanders, witnesses, et cetera. So it's an immense thing, and it's essentially people that are used to work in this and people from the country that have been trained up that are building these cases. Then there are multilateral mechanisms. I mentioned the Human Rights Council establishing these commissions of inquiry. They don't necessarily gather the evidence, but they write great narrative reports laying out the patterns of the crimes. But that's been added to. The General Assembly, in the end of 2016, established a mechanism for Syria. Would have been vetoed in the Security Council. We got a vote of 105 to 15. It's now working with CEJA, with all the other groups, consolidating the evidence, vetting it, et cetera, and then working with national prosecutors and others to build cases. The General Assembly, following up on the Human Rights Council, has now established a mechanism for Myanmar. And that will soon, as a matter of fact, the UN actually approved a budget. The mechanism for Syria, unlike the Special Court for Sierra Leone, was voluntary contributions. The one for Myanmar, because of the strong support of Islamic countries, is actually going to be paid for by the UN out of dues. So this will help build those cases. Now, where are they going to take it? Obviously, Special Court for Sierra Leone, we had a place to track Charles Taylor. Yugoslavia Tribunal in The Hague had a place to try Milosevic or Mladic or Karadzic. Of course, the ICC is a part of all of this. It has a piece. We see it in the case of Bangladesh and Myanmar, where the court has determined on the application of the prosecutor that the forcible crimes that caused the deportation of the Rohingya population into Bangladesh, that crime of forced deportation, is a crime within the ICC jurisdiction. Why? Because they had to hit the border for it to be a crime. Bangladesh is in the ICC, Myanmar, Burma is not. So it's like shooting somebody across the border. You can prosecute it in either country. So they can potentially have a piece of it. The prosecutor has yet to move for a formal investigation, but having spoken with her and her team, it will come. But there's also national systems. Now, I mentioned universal jurisdiction, the case in Belgium, where it was possible to proceed against Habre, even though Habre was in Senegal and had committed crimes in Chad. And they had some witnesses and victims there, but they weren't Belgian citizens. That was universal jurisdiction to a large extent, and frankly, universal jurisdiction is allowed under international law, particularly for torture, under the Convention Against Torture. In other words, prosecute a crime that's so serious. I mean, piracy was the great example of it in the past. Pirates bother everywhere in the world. So if you can get your hand on a pirate, it makes a difference if it's your ship, your pirate, whatever, and prosecute it. Unless somebody else knows more, has more interest in it, then you should yield to them. That caused a lot of problems because countries and prosecutors wanting to make a name for themselves get involved in something in which they really didn't have an interest, really didn't have a legitimate way to build a case that would amount to justice. But universal jurisdiction laws have been changed largely in positive ways, essentially to require that the country that takes the case have some tie to the crime. Often that's presence in the country, that the perpetrator turns up and you're saying, we're not going to be a safe haven for war criminals. That makes sense. It's your interest. Germany still has universal jurisdiction, but the prosecutor, the national prosecutor, federal prosecutor, has to make a certification that the case is in German interest, that there are lots of witnesses in Germany, et cetera. They've now done that on the Syrian regime torture, because the country has 800,000 Syrians. And part of the reason they do is because families, their kids couldn't do business, couldn't go to school without the risk of being picked up and arrested and tortured and disappeared, based upon who knows what. And so they're impacted by the crime. They've got witnesses, et cetera. They've taken this on. There's now a genocide network of international prosecutors within the EU, all 28 states, plus the US and Canada and Switzerland and Norway as observers that meets on a regular basis to coordinate work on these cases. And some of the units are highly active in terms of pursuing cases. And they're not just waiting for people to turn up 10, 15 years later and say, hey, there's a war criminal down the hall. They're actually doing things in a proactive way, working with refugee communities to find the perpetrators and to develop the cases. They're also using other forms of jurisdiction, such as passive personality. Those of you in international law know, normally in criminal cases, it's territorial jurisdiction. There's also active personality, where one of your people goes off and commits crimes elsewhere. You can prosecute them at home. Passive personality means if one of us goes on a trip somewhere and we're attacked by terrorists, and somehow our country can get a hold of those terrorists, you can try those terrorists here if they can't be effectively tried someplace else. And that's been recognized decades ago in the ICJ Lotus case. And that often applies. I think of, even in U.S. court, though it was civil, if you saw the other day the judgment in the Colvin case. Marie Colvin was an American citizen. She died reporting on the conflict in Syria in February 22nd, just a month before I gave the speech, seven years ago. And it wasn't a crossfire. She was assassinated. The government developed intelligence on her. The journalists were getting on CNN. They were getting on international broadcasts, she in particular, and reporting on how Assad was fighting the war, destroying civilian neighborhoods, arresting everybody, not calling people terrorists when they were merely calling for democracy. And they decided to find her, locate her, kill her. And with the evidence that we developed at CIJA and some insider witnesses that we also helped develop, we found the solid evidence. The family was able to take that to court in the United States, recently got a $302 million judgment against the Syrian regime for her murder. That could be a criminal case. The United States could prosecute. The main perpetrator was Assad's brother, Maher al-Assad. As a matter of fact, gave a car to the guy who killed her. And we have jurisdiction. Takes a while to develop those cases, but it can be done. We have an American, Lila Shoukhani, who was tortured and then murdered in Syrian custody in December of 2016. The French have used this already in the case of a father-son, Patrick and Mazen Draba, tortured and murdered in 2014 and 16, and they've begun criminal cases and put out warrants. Spain, in a case that I helped start, we used the sister of one of the victims in the famous Caesar photos. Many of you are probably familiar with the Caesar photos. With Caesar quite often, but he's the guy who brought out 50,000 photos of people that were tortured to death in Syrian military custody. He was a forensic photographer who had the gruesome task of taking these pictures. And he smuggled them out after 2 years of doing it. But one of the dead had a sister who was a Spanish citizen. And so we used that to start a case in Spain, which was admitted by the court. But now, whether she's a direct victim or an indirect victim is before their Supreme Court. So what's happening? We now have arrest warrants against Jamil Hassan, the head of Air Force Intelligence. We have against Ali Mamlouk, the head of the National Security Bureau, really the second most powerful man in Syria. 2 weeks ago, and I was in Germany when it happened, and with the federal prosecutor, 3 arrests have gone down of key officials involved in torture, including a former colonel, head of interrogation at the interrogation center of the General Intelligence Division in Damascus, Anwar Ruslan, now under German custody, soon to face trial. His deputy and another individual arrested in France. And what's exciting about that is that the French and the German War Crimes Unit have now formed a task force, a joint investigative task force, like an anti-meth task force or something in the Midwest. They're working together using an instrument under the European Union that allows this kind of cooperative sharing of investigation. So they can actually go to each other's countries and interview witnesses they need and do this arrest operation jointly. The IIM is now working on developing the chemical weapons cases. Just was in contact yesterday with the White Helmets, who are bringing their evidence in terms of the attack on medical and humanitarian personnel to this mechanism that's been established by the UN to begin those cases. Intriguingly, at a meeting of the ICC Assembly of States Parties in December on justice in Syria, one of the ambassadors for a very pro-ICC country in Europe said, I think we're probably further ahead today on justice on Syria, as difficult as it is, than we would be if the ICC had gotten the case in May of 2014. Because we've energized all of these other smaller boats to bring us to justice. So I do see, in the end, that we do have today kind of a third wave. And I mean, to the extent we've still got headwinds, that's the case. And to some extent, a reflection of what we developed in the first two waves plays a role in this. But a lot of it is coming together from smaller waves, and it's building from many sources. And we've got essentially crew from a lot of different countries, maybe in smaller boats. But now with, I think, the skills and the practice and the guidance to basically tack into the wind and achieve justice for the perpetrators, but for the benefit of the victims and survivors of crimes of mass atrocity. So thank you very much.
We have about 15 minutes.
Okay. Fire away. Yes, sir. So the question was, why the headwinds? I mean, you have a variety of things. I mean, countries that like China, which obviously isn't a democratic country and believes in the control by the Communist Party, et cetera, and as it gains greater strength, sees these kinds of things as affecting their power and role in the world. And certainly as it has greater influence, it used to be in Africa, for instance, and we'd see this challenge, when we deal with something like Senegal, and we're saying you need to do the right thing in the Habre case. You could have down the road another country, China, saying, we don't care if you do the right thing or not. We're going to build you a stadium. We're going to build you a new Capitol building, et cetera. We're going to do all of these things without. And so you've got that sort of, to some extent, the kind of it's a reflection of global changes. We have to deal with it, but there's that aspect of it, and certainly there's a recognition that you get these things are never easy. I mean, the Libya one is sort of a classic example. Was Libya a win or a loss? The international community sought the ICC's jurisdiction. The ICC never got a hold of anybody, but there was an intervention. Gaddafi left. And Libya is ungovernable today. I mean, obviously, nowhere near. I mean, I think something like 10,000 people maximum have died. It's not like 500,000 in Syria, but there are elements of that where people sort of say, well, we'd be better off if the dictator had just stayed in. He could have kept everything down, and nobody would have left, et cetera, and we can just ignore that situation. That I suppose has some people sort of practically looking at it, but on the other hand, when dictators go, like the Shah in Iran, and then you get something really bad, et cetera, eventually these pressures build, and you end up with even a worse situation. So, establishing these norms and enforcing them is important. But, and even in the context of Europe, where Europe used to be pretty solidly for human rights, the effect of the refugee crisis, particularly from Syria, but also people crossing, using the fact that Libya is uncontrolled to get out of countries further south, has had an impact and has made European countries where the EU has to operate essentially by unanimity much less forward-leaning in this area. And so, a variety of things are happening that I think have reduced the sort of a push. Now, there's still possible. I mean, we talk about Yemen, for instance, difficult issue, war between an Iranian and a Saudi-backed factions, basically. And there are bad things being done on both sides. The UN Human Rights Council last year established, even though the Saudis said we don't want it, by 21 votes out of 47, and the council voted yes, 8 voted no, 18 abstentions. So there's a commission of inquiry on Yemen. So it's possible to do some things, to begin to build some things, but you don't have necessarily the push. Now, sometimes things come together, as I said in the Myanmar context, even though, the whole situation with Aung San Suu Kyi and the government in Myanmar, and we can talk about that, creates, is she in charge? No, not really, and the military is doing these horrible things, and we've got this whole issue of the Rohingya population, which they say these people aren't ours, they belong in Bangladesh, they're Bengali, even though their families have lived there for generations. you have these horrendous crimes, and nothing, and Myanmar, Burma's not acknowledging them. On the other hand, the Islamic countries who see these Muslim victims being pushed out are united on this one. And so this is one of the reasons why we're able to get a vote in the General Assembly, 142 to 10. Of course, we've gone to the Security Council. China, who wants Myanmar on side, wants Myanmar to be its port on the Indian Ocean, et cetera, would be voting against it, and it'd be a veto. So there are ways to get there, but in particular, since a lot of these things relied on the Security Council in the past, that particular route, certainly beginning with the Syria referral, and with the inability even to put any kind of sanctions on the government, and nothing. We've not been able to, and even the chemical weapons investigative team was established, but then when it came up with the wrong answer in the Russians' view, it was abolished, et cetera. So you've had this kind of act in the Security Council of protection of bad actors, and so that doesn't work. So we have to find these other routes. Not that there aren't people all over the world that support these values, but the global institutions aren't unified to do something about them. And in the past, that's in the first wave, victory in the war. Second wave, Security Council acting unanimously in the sort of Yeltsin era of Russia. We could do that. That's in the past. So now if we're going to get progress, we have to find other ways.
So I'm wondering what are the available prosecutorial mechanisms for countries like Yemen, where they are, so Yemen is signatory to the Rome Statute but hasn't ratified it, for trying war criminals, genocidaires. So I suppose that means that the ICC is unavailable, but it also seems true that an ad hoc tribunal wouldn't really be feasible at this time either. So what mechanisms are available for bringing these people to justice?
Not easy. I mean, I mentioned, obviously, Syria is a case where, to some extent, I mean, the dynamic is certainly different, but eventually it was possible to do cases in third countries. And certainly over time, in a Yemen context, you may have individuals that are associated with one side or another traveling in Europe, and you may have that opportunity. A little less likely than with Syria, with its coast on the Mediterranean, but there is certainly that possibility. Yemen has always been a difficult case because of its relative isolation, and it's gone through some bad times even back to the 1960s. I do think that in this one, whatever sort of we hope that we can have peace, and there needs to be peace in this country. It's not possible for one side or the other to win. To the extent that this has sadly become a Shia-Sunni division, you've got a country that's like 55-45, so it's not like one side or another can win that and have a stable country. So there will need to be peace, and there will need to be the development of at least transitional justice institutions where people can find out the truth, if nothing else, about it. Once you do that, you may have the pressure to establish justice. Now, keep in mind that when this whole thing, when the present situation, I mean, we had President Saleh, who it was in 2012, gave up power. The Gulf Cooperation Council, the Gulf countries, essentially negotiated a peace where he was left power and was given amnesty. He then decides he doesn't like that anymore. He allies with the Houthis in trying to take back power, et cetera. And so, to some extent, this is an example of these amnesties, say, forgive and forget. Well, just do it again then, next time I'll win, et cetera. So you have that difficulty of not having had a justice process. That also is a problem in the Middle East generally, that unlike, we haven't had a tribunal like Sierra Leone or an ad hoc tribunal in the Middle East, for instance, and you haven't had the countries in the region having a human rights instrument like, say, in Africa or in the Inter-American system, et cetera. See, and the League of Arab States, for instance, it doesn't get involved in these kinds of issues. So it's been a difficult place to get traction on it. But I would hope that as one develops a peace process, and the kind of peace process in which, like we did in South Sudan, though we're still not seeing its implementation, you get the public involved in civil society. People are saying, we need to have justice. We've got to have guarantees that this won't happen again. And so, and then the international community has to be serious about following that up. Do keep in mind, what I always say about these things, and I said about Syria when nobody thought we'd be arresting people in Germany who were associated with Assad. Let's develop the evidence. That's what this project is about here, working with students and working with Yemeni civil society and survivors groups, et cetera, is develop the strong evidence so that you can find your way into court, so that it won't be a question of well, they did horrible things, we know they did horrible things, but well, no, that's just fake news, as far as the other side is concerned, things that you can prove. And so a key part of this, and my current passion is always document, have that 3 times as much evidence as you need, and you'll find prosecutors somewhere, somehow, that will get you into court. Yes, sir.
Are you generally a supporter of truth and reconciliation committees in some of these countries, or do you view them as possibly hindrances to peace agreements, such as in the Good Friday Accords?
Well, I'm a supporter of truth commissions. We have one in Sierra Leone. It came out of a different sort of whole peace agreement than the Sierra Leone court itself represented. And commissions are not all the same. They're not equally effective. But I do think that there is enormous value to people being able to tell their story and get it on the record. Some in public hearings, others secretly, privately, confidentially, et cetera. And bring experts together that can help research and develop some of the other evidence that's not available from testimony. Of course, they're particularly useful if you can get some perpetrators to come in and make a clean breast of it, et cetera. And sometimes that happens, often it doesn't. I'm not in favor of sort of blanket amnesties, though I'm certainly willing to look at I think what's happening in Colombia, for instance, with the Truth Commission, and also with the ability of people, even senior people who've perpetrated crimes in the FARC or in the military, if they give a full confession and pay reparations, et cetera, they can get a sentence of house arrest of up to 8 years and not jail. I mean, I'm a former prosecutor. I made deals for justice, and having somebody actually stand up and say, I did it, and pay for the victims, et cetera, that's a lot. Sometimes that's a lot more than you get when you spend 6 years in court in terms of a judgment. So I'm willing to take a look at that if the public agrees with it, et cetera. I mean, this is fundamental. But the idea of washing it all away and having an amnesty and having a few people give statements, self-serving statements, and call that done, that is not enough. So I think the Truth Commissions, and frankly, when they're done right, they usually lead, as the case in Liberia, and I was there recently. Liberia, we prosecuted Taylor at the special court, but of course, we did it for the crimes he committed in Sierra Leone, and so there's never really been justice in Liberia. Now there's an enormous groundswell that wants to have justice, and they had a Truth Commission. A lot of the perpetrators came and boasted about how many people they'd killed. And the commission recommended a special court, but it was never implemented. And quite often, when you have these truth commissions, this is what awakens and their reports are what awakens the demand for justice. But of course, that justice is never, let's prosecute everybody. It has to be focused on the really horrible acts or on the people that made it happen, that profited from it, and find other routes to reconcile and to get reparations from those who are at a lower level. Questions? Yes, sir.
I'm going to embarrass myself, but why is the U.S. not a member of this? Do you have any understanding there? They apparently have some role, and how do you expand the role?
I mean, the practical issue on why the U.S. isn't in the ICC is it's a treaty-based court, and treaties take 2/3 of the Senate. And ratifying treaties, the last time we ratified a controversial one, I think it was Panama Canal, et cetera, and people supported that, many of them were defeated. So it's difficult to do treaties. Even the Disabilities Convention, the United States made a real effort in 2012 to ratify it. And Bob Dole, who'd been, of course, Republican leader, who was disabled and spent 39 months in hospital, never had full use of his right hand, was on the floor lobbying his former colleagues. And the high water point we reached was 62 votes for the Disabilities Convention, and it needed 67. And the argument was, well, the Disabilities Convention's weaker than the Americans with Disabilities Law. Well, there's two parts of that. One is, well, then it wouldn't hurt us at all to join. And the argument was this would make us much more effective if we're going out and advocating that other countries deal with their disabled populations appropriately. We wouldn't get the argument, well, you're not even in the treaty. And it wouldn't make us do anything we're not doing already. Others said, well, if we're doing it already, why do we need a treaty? And there's that American attitude, well, who needs a treaty on incitement to this or that? We have our First Amendment. We have these laws. We don't need that. So you do have that sort of strong attitude, and it's made it difficult to get human rights treaties ratified in the U.S. The Convention on the Rights of the Child, a few years ago, the Supreme Court noted it had been ratified by every country but two, the United States and Somalia. Well, Somalia has since ratified, so we're the only one that hasn't ratified that treaty. So that's difficult. But the ICC is even more difficult because it could have jurisdiction over Americans if we hadn't shown that we had investigated ourselves and held our own people to account in the cases of the most serious atrocity crimes. And that's strongly opposed. The idea we can do it ourselves meant the U.S., I think, will never in its current, I can't foresee a situation where the U.S. would ratify the ICC. It makes it difficult when we deal with other countries who've passed these laws and said even that their queen can be prosecuted, and we say, no, you can't do this. But we were able to explain and develop a relationship nonetheless. But that's an issue we deal with in international diplomacy and a kind of a political reality. Understand in most countries, treaties can be sometimes approved by the cabinet, sometimes approved by a simple majority of their parliaments. So it's not as difficult constitutionally elsewhere as it is here. So it's both institutional and I think cultural, in terms of our approach to these issues. But at the same time, we've been a leader in this field, of course, always in cases involving others. But we also have very effective prosecutions of our own people. The Blackwater guys convicted for Nazur Square murders, or Sergeant Bales who killed 16 people in Kabul and got a life sentence, et cetera. So we do hold people to account, and our position is we'll do it ourselves. Nobody else needs to do it for us. And as long as we're true to that commitment, I think we can make this work. Okay. Thank you.
How about another round of
Thank you.
So we'd love for you to join us for a reception in the Rotunda. We have food and drinks, and Ambassador Rapp would love to get to know you and answer more of your questions. So if you'll allow him to move in that direction before you grab him, then he'll be able to talk to all of you. Thank you.
Okay. Have fun. So
that was great.
Covered the waterfront.
Oh, yeah.
Sorry, do you continue to use the waves boats?
I love it. Are you a sailor?
Well, I've done tacking. My wife taught me how to tack, in small sailboats. Yeah.
I think I had a meeting with
And all the sailing records.